Thank you. Honorable Chief Justice, Honorable Attorney General, and the senior members of the Bar, Dean Law Faculty, KDU, ladies and gentlemen, very good afternoon to you. And I consider it a great privilege to be among the distinguished gathering here today. And also, let me thank the organizers of this symposium for inviting me to make this presentation on criminal justice system. I have a small, PowerPoint presentation prepared. I hope that will help you understand better what I am trying to, say here today. To talk about criminal justice system, we need to first understand about crime. Crimes are socially unacceptable behavior which will entail state-enforced punishments. Now, there is a clear nexus between crime and political society. As many would agree, submission of individuals to the political society is the foundation of modern democratic state. This submission is to a very large extent is based upon the expectation that the political society shall in return provide to the individuals and their loved ones protection of person and property against crime through a properly administered system of criminal justice administration. Now, administration of criminal justice includes investigation and prevention of crimes, prosecution of suspected offenders, adjudication of guilt, and enforcement of punishment. Administration of criminal justice is an essential and inalienable function of a modern state. If the protection provided against crime is vague, or if the protection provided is intermittent or substandard, then the confidence of the general public in the state and its organs would diminish, giving rise to societal misery and anarchy, maybe even leading to what the Attorney General said, compelling the individuals to take law into their own hands. But on the other hand, criminal justice administration is a cutting edge of state power, because it's in this area that the state power could be most devastating on individual freedom and liberty. How a state responds to crime and the manner in which the powers incidental to criminal justice administration are used are acid tests that demonstrate to what extent the state is civilized and democratic. Providing protection against crime is a political necessity that is important to maintain social stability and peace. In turn, social stability and peace are the foundations of economic development, which we all need. But achieving social stability and peace at the expense of individual freedom and liberty can be counterproductive. While it is important to punish wrongdoers, it is equally, if not more important, to ensure that innocent is protected. Thus, the rule of law demands that the enormous powers incidental to criminal justice administration be exercised with utmost respect to due process of law. I've given the two models, crime control model and the due process model. Now the crime control model is primarily based upon the predictability of guilt of suspected offenders, whereas the due process is primarily based on the presumption of innocence. Now, in the system we have here, the due process, we have a mix of due process and crime control, but there are at times we see biases. But as the Constitution has stipulated, investigation, prosecution, and trial against crimes must begin, continue, and brought to conclusion in accordance with the provisions of law, while respecting the rights and freedoms of suspected offenders. These apparently contradictory but equally important objectives of politics and law pose a complex challenge to criminal justice administration. They require the criminal justice administration process to maintain an equilibrium between the need to ensure security of the community against crime on the one hand and the responsibility to uphold the due process of law on the other. The Sri Lankan criminal justice system, if you look at, is primarily based upon the penal code and the code of criminal procedure. The penal code of Sri Lanka was enacted way back in 1883, and it lays down the limits of socially accepted and unaccepted behavior and stipulates punishments to socially unaccepted behavior. The crimes described in the code are divided into two major groups, namely grave and minor. The minor has several subgroups. And Section 52 of the Penal Code has provided 6 different types of punishments: death by hanging, rigorous imprisonment, simple imprisonment, whipping, which was later removed, forfeiture of property, and fine. The Code of Criminal Procedure prescribes the procedure to be followed in investigation, prosecution, adjudication, and punishment of wrongdoers. Some limitations are also stipulated in the fundamental rights enshrined in the Constitution. The Penal Code and the Criminal Procedure Code together provides the legal basis for state action taken against offenders. Now, despite the wide variety of amendments made to the Sri Lankan Penal Code from time to time, the fundamental and conceptual framework of the code has remained substantially unchanged. The language of the code and the way how the punishments have been stipulated are clear indications of the legislature's intention of giving the penal code a retributive disposition. The policy and practice with regard to procedure also demonstrate a bias opposite of the due process model. Moreover, though Sri Lanka has adopted legislations such as Probation Ordinance, Community Sentencing Act, which provides some sort of a rehabilitative process for offenders, these, my Lord Chief Justice, these measures have not been as popular as punishments provided by the Penal Code among the judges. The unprecedented transformations of the Sri Lankan socio-political landscape since the end of the war, 30-year war, has posed formidable challenges as well as created space for the entire spectrum of civil activity, which includes judicial work as well. To adopt and introduce changes to suit the new circumstances created by the newly found peace and political stability. These opportunities and space must be used prudently to remove centuries-old policies, procedures, and practices that had not evolved in parallel with socio-political changes in the country. Although changes are essential, the changes must be introduced only after scientific studies, only after scientific investigation. Ad hoc and piecemeal changes can be counterproductive. For example, as Steve Aglow has noted, a mere widening of the criminal justice net to control crime would, instead of reducing crime, inevitably put more pressure on the agencies of state involved in administrating criminal justice. For example, creating more prisons would obviously create a need for more prisoners. Finally, whether a crime-free society could ever be created is extremely doubtful. It must be noted that the definition of crime or the definition of socially unacceptable behavior keeps changing with socio-economic developments. For example, insider dealing or insider trading, which was about 2 decades ago regarded as clever use of the system by sharp manipulators, is a severely punishable offense presently in many countries. It is also important to note that criminal activity provides a means of living not only for the criminals and their dependents. The antisocial activities of the criminals provides employment for many thousands of police personnel, lawyers, people working in courthouses, including judges, my lord, for crime journalists, and also for academics involved in teaching criminal justice. Now I conclude my presentation with a small quotation, although I do not agree with most of the things Karl Marx had said, but I take a small quotation to conclude my presentation from Karl Marx's theory of surplus value. Would the locksmith's trade have attained its present perfection if there had been no thieves? Thank you very much. With that, I conclude my presentation.